Hello, everybody. I'm Stephanie Bivens, and we appreciate you joining with us today on our webinar. We still see we've got some more people signing in, but since it is now noon, we'll go ahead and start with introductions. So as I mentioned, I'm an attorney, Stephanie Bivens, here at the law firm of Bivens and Associates. And today's speaker is going to be Megan Selvey, and Megan is with us today as well. Couple of housekeeping notes. During Megan's presentation, we're going to be talking about exploring the different types of special needs trusts. So if you have a loved one in your family with disabilities or special needs, this is going to be a very informative session. I know there's probably lots of questions that people have. So if you want to use the Q&A feature in the webinar to submit your questions, Megan and I will be sure to be watching out for those as they populate and come in. And if we don't get to them right away, it's because we know we're getting to them in a minute. And also feel free to save your questions to the end if you want. We'll be sure to save a few minutes to have questions at the end of our presentation today. So with that, Megan, I'm going to let you take it away.
Sounds good. All right. Hi, everybody. I'm Megan Selvey. I'm one of the attorneys at the firm. Today, we are going to be talking about different types of special needs trusts and there's some notable things. I'm going to share screen. Stephanie, can we see my slides? Okay, perfect. All right. So maybe we can do this. Yeah, there we go. All right, so a little bit about me. I've been with this firm for a decade now. Can't believe we can say that. And if you're maybe new to our firm, this is all we do. So we are doing estate planning, post-death planning, special needs planning, and elder law, and kind of the areas that fall into those. We have been in practice for, I think this is outdated now, it says over 18 years. It's really longer than that. And being special needs planning attorneys, so we get all types of questions about what kind of special needs trust is appropriate, and it depends on so many different things. So first thing I'm going to talk about today is just general goals of a special needs trust, and then we're going to talk about the different kinds of trusts so that hopefully it can offer some clarity for like what kind of trust would be appropriate for certain types of assets or certain circumstances, and then we can answer questions at the end. So first of all, just some context, right? Like, why would you even want a special needs trust? So the goal of it would be there's somebody that needs to benefit from some assets. And the hope is that those assets make the life of the beneficiary a little better. So we're, enriching the life. It could be providing for medical care or entertainment or quality of life or well-being or standard of living, things like that. The nice thing about the entity of a special needs trust is that it allows for prudent management of assets by a trustee. So there's a neutral party who's not the beneficiary who's in charge of the assets. So the beneficiary has the benefit of the assets, but they don't have the burden of management. It can protect the beneficiary's public benefits. So what we mean by public benefits would be Social Security benefits or Medicaid benefits, or those are the two big ones that have asset limitations. So assets that are held in a special needs trust don't jeopardize those benefits for the disabled person. It offers creditor protection for the beneficiary. So the beneficiary has creditors, or if they, have existing creditors, or if creditors come up in the future, the assets of the special needs trust are not available to the beneficiary, so they are not available to the beneficiary's creditors. And then the other thing a special needs trust can do is it can yield tax efficient outcomes, especially when in certain circumstances, there's tax deferred assets that are left to special needs trusts. Special needs trusts can provide favorable payout options to the beneficiary. So those are some goals. There are many more goals, but those are some notable ones. So different types of special needs trusts. So the really important distinction is, where is the money coming from? Is it coming from the disabled person themselves? Meaning that it's their money they've already received in their own name, or they're entitled to receive in their own name. Maybe they are the plaintiff in a settlement. They got in a car accident and they're getting money as a result, or a family member passed away and left them money, and that money was never held in any other type of special needs trust or supplemental trust. It's just, you know, unfortunately payable to the beneficiary, and it puts their benefits at risk. Those kind of trusts are what we would call, or those funds are payable to the disabled individual. They are the first party, meaning that funds are in their name. They're perhaps receiving Social Security or Medicaid benefits, so that they are limited to the assets that they can have. So there's a big problem because they're receiving assets. It's over the limit they're allowed to have and keep their benefits. So what's the fix? That fix is what we would call a first party special needs trust, or there's another version called a pool trust. So we're going to talk about those. There's a whole other dynamic here where you've got a beneficiary who has Social Security or Medicaid benefits, and there are other people in their life that eventually would like to leave them something. So the goal for those individuals, so for a mom or dad or grandma, grandpa, or siblings, would be not to make the mistake of leaving money to that person directly, but instead hold it in a different kind of special needs trust, which, just a note, when we are drafting those third party trusts, meaning it's being funded with third party money, we usually call them supplemental needs trusts to distinguish between the two. So we're going to talk about all of these different types of trusts, but the really important distinction, again, it comes back to, where is the money coming from? Is it coming from the disabled individual, the first party, or is it coming from a third party that wants to provide for them? Because those are two totally different concepts. Okay, so we're going to start by talking about when the funds are coming from a third party. So I'm going to probably use the terminology of parents wanting to provide for a child, only because that's a common scenario that comes up. So it could apply to any third party, though. It could be a friend who wants to provide for a friend or a grandparent, but usually we often see parents providing for a child. So that's what I'm going to talk about. So one type of special needs trust, so I'm going to also call this a supplemental needs trust because I think it offers clarity, would be parents think, you know what, we have our accumulated net worth. Someday we know we're going to have the reality that we're going to pass away, and this accumulated net worth we want to go to our son or daughter who receives public benefits. So how do we structure that so that we're helping them, not hurting them? So parents might choose an option that's themselves setting up a revocable trust, and they might set up in that trust a term saying, upon our death, all goes to, or a percentage goes to our child, but we're holding it in supplemental needs trust. Parents get to choose the trustee. Beneficiary, so son or daughter, receives creditor protection from those assets, meaning their own creditors are not entitled to receive the assets. The assets of the special needs trust do not count for Social Security or Medicaid purposes. The assets come from the parents, and they never get directly titled into the name of the beneficiary. So that's why the public benefits are protected. The assets are inherited basically by the supplemental needs trust at death. And then the trustee, who again was chosen by the parents, has discretionary authority to make distributions, meaning that the trustee can make distributions for whatever they feel is in the best interest of that child on an ongoing basis. And then the wonderful thing about this is that parents get to choose who the ultimate beneficiaries are. So say there are funds remaining in the trust at the death of the child, parents could redirect that to, the other siblings or, whoever they would want. There's not this mandatory repayment of the balance to Medicaid, which is a real advantage to planning ahead with intention, with foresight, and parents doing their planning. Because as we're going to get to when we talk about first party trust, if funds were accidentally left into the beneficiary's individual name, and then we had to do a first party trust, there is a Medicaid payback. So I would call this planning option 1 for third parties. Family members create their own trust, and then at their death, it funds a special needs trust, but really I'm going to call it a supplemental needs trust for the beneficiary. The same type of planning could be done through a will, like for the parents, versus a trust for the parents. So for anyone that logged on to our webinar yesterday, Stephanie gave a beautiful discussion about trust versus wills and when you might use one or the other. Both could create a special needs trust for, a beneficiary under either document. A really notable difference is that mom or dad, or, grandparents, family members, whoever, creating a last will and testament that creates a supplemental needs trust at death. It's really hard to have a good tax deferment result for IRAs if that kind of trust were to be named the beneficiary in an IRA. So without getting into the weeds of that issue, I would just say one of my warning flags when people ask me, okay, I want to create a special needs trust for my son or daughter, and how do I do that? And should I do a trust for myself to do that, or a will? One of my first questions is, tell me what you have in an IRA or in a 401k, and let's talk about where that money you want that money to go. Because if the goal is for those funds to also provide for your special needs beneficiary, then this is very likely not the structure that we're going to recommend. But special needs trusts created under the terms of will have all the same advantages. You choose the trustee, there's creditor protection for the beneficiary, you're protecting the public benefits, the trustee makes discretionary distributions, and there is no mandatory Medicaid payback. Okay, sometimes we do a whole different kind of structure, and that's where we would do a separate trust document that is only a supplemental needs trust. It's like maybe mom and dad have their estate plan, but then they're doing a whole separate special needs trust. Why would you do that? Oftentimes we are doing that when we are expecting or want to preserve the option for multiple contributors to contribute assets to this kind of special needs trust. Because if it's a standalone entity, it's its own trust entity, then multiple parties could name that trust as beneficiary on accounts or contribute funds. This could be drafted as revocable, at least until certain events come up, or it could be irrevocable, meaning it could be changeable for a period of time, or totally unchangeable. It kind of depends on a family's goals. But the creators of it, so let's say mom and dad are creating this, then again, they choose the trustee. There's still creditor protection for, on behalf of the beneficiary. The trustee still has discretionary authority to make distributions. The assets are still protected from being countable for public benefits, and there is still no mandatory Medicaid payback. So this is a useful structure. We see this a lot, you know, and I think the most common scenario where this could be really, really helpful for a family would be, you know, there are just multiple family members that want to provide for this person, you know, and so maybe this is the way that we go. Okay, so I want to contrast all of these three options that we've talked about so far, where the funds to fund the supplemental needs trust are coming from family or friends, versus a whole different kind of special needs trust where the funds are funds already of the disabled person. And that is problematic because they receive public benefits that don't allow them to have funds in their name. This is what we call a first party special needs trust. This statute 42 USC 1396 D4A. This is the federal statute that creates this kind of trust as an option. It is what I would refer to as the emergency fix, right? So we get a panicked call from someone that says, oh my goodness, Mary receives ALTCS benefits, which is Arizona Medicaid. And wouldn't you know, great Aunt Ida just passed away and she left Mary $100,000, which is just enough to, it's definitely enough to interfere with her ALTCS benefits, but it's not necessarily enough to fund her care for the remainder of her life. What do? Well, if Mary's under age 65, this is definitely an option we're going to explore. So basically, the trust can be set up by the beneficiary themselves, if competent, parent, a grandparent, legal guardian, or the court. The funds can be contributed to the trust. They have to be funded to the trust before age 65, meaning an account has to be opened. Funds have to make their way into the account before the beneficiary turns age 65. There is a Medicaid payback. So here's what this means. At the end of Mary's lifetime, if there are funds remaining in the trust account, Medicaid is going to present their bill. They're keeping track of funds that they expend for people on the program. And they're basically going to make a claim. Obviously, their claim is only for up to the amount of that's left over. So the claim that we see often exceeds what is left in the trust, but they're only entitled to what's in the balance of the trust. If different state Medicaid programs have provided services, then they all, you know, will have a payback claim. Here's one thing to consider about a first party special needs trust. So Medicaid, so in Arizona it's Access, ALTCS is just one program of Access. They must pre-approve all distributions from the trust. So the trustee basically prepares an annual budget and Medicaid approves or disapproves of line items on the budget. And if there are things that come up that need to be paid for that aren't on the budget, ALTCS needs to give special approval, basically one-time approval for those distributions. So aside from the ultimate Medicaid payback, the ongoing coordination with ALTCS on administering these trusts, and it's significant. And that alone hopefully would be motivation for families to do planning ahead of time and make sure that assets are routed into a third party special needs trust and not left directly to a beneficiary, because you know the daily in and outs of administering this kind of special needs trust and coordinating with ALTCS can be tedious, I'll say it that way. And it's certainly, like, if it could be avoided, I would recommend avoiding it. We help trustees who are, trustees of special needs trusts. We give advice on how to, coordinate with ALTCS and get approval for distributions. And so this is work that I do all the time, and I'm heavily involved in this kind of thing. And there are a lot of rules to consider. So that's why it says ongoing legal assistance likely, very likely. There is creditor protection for the beneficiary. The trustee does have discretionary authority to make distributions. And then the creator of the trust, so like I said, beneficiary, parent, grandparent, guardian, court, when setting up the trust, they choose the trustee. So, and then often the assets that I see going in here are when, the beneficiary receives assets and it's unavoidable. Like it's their settlement, they're the plaintiff, we can't avoid that. Or if they receive an unplanned inheritance, those are the two most common scenarios. There's a whole nother option, which is another kind of first party trust, but it's called a pooled trust. So there are pooled trusts that in Arizona, we have several that operate. I don't know if every state has one. I'm actually really not sure, but in Arizona, we've got several different options. Basically, a pooled trust is run by a nonprofit company, and they create a master trust agreement, and they submit that master trust agreement to Medicaid and Social Security, who pre-approves the master trust agreement. And then beneficiaries can join the trust. And basically a lot of different beneficiaries can pool their money together. Pooled trusts are happy of beneficiaries with any, level of assets to join, but certainly it's a very helpful option for beneficiaries that don't have assets that really justify the setup cost for a D4A trust, like a standalone first party trust, or just don't have assets that justify kind of the ongoing administration of that kind of trust. So this is a really, really great option for certain beneficiaries in particular. And the assets are not considered countable assets for public benefits programs. We can also use it as what I would call an emergency fix. So if someone inherits money or receives a settlement and they want to join a pooled trust, that's a great option. Creditor protection for the beneficiary, yes. Discretionary distributions by the trustee, yes. So the pooled trust company serves as the trustee. So there is not a family member trustee. So sometimes that's an analysis that, the family might want to make. Yeah. So when we are thinking about what kind of special needs trust is appropriate for the circumstances, first think about where the money is coming from. So if it's already the money, the funds of the disabled person, so it's like money that's already in their account, or they are legally entitled to receive it, like it's a settlement or an inheritance, then we know we're going the first party route. And it's just a decision of, is there a standalone trust or are they joining a pooled trust? But when most times we're not talking about a first party special needs trust. A lot of times when people will call our office and they'll say, I think I need a special needs trust, what they really mean is that there is, family member or close friend, somebody who's receiving SSI or ALTCS, Social Security or Medicaid benefits, and they know that they can't have more than $2,000, and yet there's family members that want to ultimately provide assets to them. So like mom or dad have assets, eventually they acknowledge they're going to pass away, and they know they need to protect those assets from being countable for the beneficiary. So I always recommend thinking about first, what are the assets that are potentially going to be funded to this trust? So we got to think about, is it property, real property, personal cash, Is it retirement assets, meaning IRAs or other tax deferred assets, qualified accounts? Because that is a very significant component to the puzzle. That's a good starting place for parents to think about, you know, what kind of trust they want to do and what kind of structure. And then the other thing I would recommend is thinking about, are there other people that you think are going to want to contribute to this trust or not? If parents do their estate planning and they are setting up a third-party special needs trust for their beneficiary, you know, just from your friendly neighborhood estate planning attorney, don't forget to fund your parents' revocable trust. So when parents are setting up their estate plan, or, you know, somebody creating the documents is one thing, you know, titling assets and making sure a trust is funded is a whole nother step, and it's a equally important step. So follow your instructions from your drafting attorney. And then I'm going to pause here and then answer one question. Someone had asked, sorry, I don't know if I pulled that question up, but I want to make sure
Yeah, Megan, the question is, access is what department?
So, let's go back to here. Medicaid is a federal program. Every state implements their own version of Medicaid. In Arizona, our version of Medicaid we call ACCESS. It's an acronym that stands for Arizona Healthcare Cost Containment System. So think of ACCESS like the overarching Arizona Medicaid umbrella, and they have ACCESS has a lot of different sub-programs. So one of their sub-programs is a program that provides long-term care services for individuals. That program is called ALTCS, Arizona Long-Term Care Systems. So ALTCS is the program that has the $2,000 asset limit for its eligible recipients. So, you know, oftentimes that's a little bit of sleuthing that we need to do before we figure out if establishing a first party special needs trust is really appropriate, is figuring out, is this beneficiary receiving public benefits where there's an actual asset limit, right? Like, are they receiving ALTCS and subject to a $2,000 limit? Are they receiving SSI and subject to a $2,000 limit?
Great, thanks, Megan, for the clarification.
Thanks. Are there any other questions about ALTCS or public benefits or maybe anything like that? Otherwise, I can go into more on administering.
Megan, I think it might be helpful for the audience just for you to spend 2 or 3 sentences on the differences between SSI and SSD benefits and which one is means tested and which one is not, because I know a lot of people are uncertain about that.
Sure. Yeah, and that's probably worthy of its own whole webinar in itself, is just differences in public benefits. But you know, Social Security, again, federal agency, has a lot of different programs. So one program is called Supplemental Security Income, SSI. So SSI is a benefit that can be awarded to somebody that's indigent, meaning they have low income and low assets, and Social Security imposes an asset limit of $2,000 or less in countable assets. And basically the theory behind SSI is, you know, we as a society have collectively decided there should be a minimum amount that somebody who's disabled and indigent should be able to receive, meaning that they can't work and they have no other money, in order to provide them money that they can use for food or shelter. So that's what SSI is. The maximum monthly benefit in 2023 is $914. So, you know, I don't know that that gets you food and shelter anywhere, but that's the maximum benefit. And so somebody who's receiving SSI income, naturally, right, they're going to be very protective over maintaining that source because that's all they get to provide for food and shelter. And so, you know, if they're looking to receive a $50,000 settlement, you know, again, the analysis is probably that's not enough to get me to independence or take care of my care costs for any like length of time. So I have to keep my SSI benefit. And so they might, you know, really be concerned about protecting it. So we're always interested if someone receives SSI because that's the benefit with the $2,000 limit. So there's a whole other benefit through Social Security that's called disability benefit. And so somebody who has an actual work history, you know, they've, you know, generated credits in I think they're called credits in the Social Security system, and they become disabled. They can no longer work. Social Security verifies that they meet the disability criteria. They might receive disability benefits where they are receiving a benefit based on their own work history. So that benefit is dependent on that person remaining unable to engage in substantial gainful activity. So they have to remain disabled, unable to work. It doesn't matter what their countable assets are. So that person would not necessarily need to establish a first party special needs trust because they don't have a benefit that puts a cap on their countable assets. There is a whole nother benefit where someone who receives SSI, so that's, you know, someone who's indigent and disabled, no work history of their own, has a parent that then becomes retired or deceased. Then the disabled adult child might begin to draw on parents' work history, basically. So their SSI benefit then transforms into what we refer to as Social Security disabled adult child benefit. So it's always like when we meet with families, it can be challenging to try and discern which Social Security benefit someone receives. And I think it's equally confusing for families. And so, you know, we may ask for source documentation like a Social Security award letter, or we may be able to figure it out just based on the amount someone receives. So if someone's getting, you know, close to $2,000 a month in Social Security, I can confidently say that's not SSI because SSI has a maximum benefit of $914 a month. So.
Thanks, Megan.
Okay. So if there are other questions, stop me. Otherwise, I would say I'm going to talk about for a third-party special needs trust, kind of what that looks like at time it's being created and funded. So if parents put together an estate plan, so whether it's a revocable trust or a last will and testament, and the estate planning document says at our death, 100% of the assets go into a supplemental needs trust for our daughter, Mary. Then what actually happens, so I get this question a lot, which is why I wanted to talk about it, is like, how does that work? How does the special needs trust become a thing? So there will actually be a separate tax ID number at the time obtained, a separate bank account opened with that tax ID number, and funds will actually go into a separate account. It'll read something like Mary's Supplemental Needs Trust. And so basically, you know, the trust document is the guiding rules for what happens to the assets in that account. So the document will say something like, the trustee has sole and absolute discretion to make distributions. The trustee of a trust in Arizona is supposed to render an annual accounting to the beneficiary or their legal representative or guardian. So, you know, parents in selecting a trustee may want to think about somebody who has kind of the acumen to be able to manage the account, seek advice where appropriate, you know, manage investments, identify the needs of the beneficiary, make appropriate distributions, prepare an annual accounting and submit it to the beneficiary or their guardian. So there's a little bit to it. But basically that's the nuts and bolts for how it works. And then I guess I just wanted to mention to parents that, or anyone who's thinking about, you know, providing for someone through the mechanism of a special needs trust is that, once it's in place, I would say it's prudent to review it periodically. Nothing in this area of law is insulated from change, meaning, you know, we're dealing with intersection of a lot of different laws. We're dealing with federal law and state law and Medicaid rules and Social Security rules. And so it's a good idea just to check in from time to time and make sure that the plan, like the structure of the plan, is a good structure, or the way things are drafted. We don't need any updates. Probably, I mean, the most thing that changes most often is the ALTCS manual. So sometimes that inspires changes and sometimes it doesn't. So I would say certainly if documents have been created prior to 2009, but you know, really every 3 years it should be looked at. So I guess prior to 2020, I should say. The reason I put 2009 here is that, you know, there was a big legislative update in Arizona in 2009. So anything older than that, I think, is worthy of an update, certainly. If you have not reviewed your plan with somebody in 3 years, it's a good idea to review your plan. Any family changes, personal changes, economic changes, or if there's been changes in the beneficiary's benefits, things like that. All good reasons. If you move states, all good reasons to update a plan. I think. Oh. Let's talk for a second about elder law versus, I guess, someone who's not an elder law attorney. So what an elder law attorney is someone who's well-versed in public benefits. So like Medicaid or Social Security or DDV, even in this conversation, which really is a conversation about estate planning, right? We're talking about setting up documents to provide for someone, but you can't understand special needs trusts without a robust understanding in what the trust is supposed to protect. So Medicaid benefits, SSI benefits, and what all the rules for those benefits are. So an elder law attorney is someone who understands all of those public benefits and understands how things should be drafted in order to coincide with those agency rules. Elder law attorneys that we also deal with all the time, trying to protect assets from these agencies, draft special needs trusts, and we deal with the public benefits agencies all the time, sometimes happily and sometimes tediously. Okay, that was slides, so I'm gonna leave it here and maybe we can address questions.
Yeah, so Megan, there was a specific question just related to when you mentioned ALTCS manual. What does that terminology just mean?
Oh, the ALTCS manual. So the Medicaid has its own set of rules, but basically what it is Medicaid rules. So Medicaid, that's a bad answer. Medicaid has its own rules that appear in federal statute, but each state's Medicaid agency basically publishes and regularly updates their own manual. So I said a few minutes ago, Medicaid is a federal program, but each state implements its version of it. So each state will have its own manual, and that is that state's version of how they're implementing Medicaid. So each state is allowed to basically adopt its own rules for their long-term care program. I mean, the broad strokes rules are going to be the same generally throughout. So $2,000 asset limit, but in Arizona, like ALTCS has its own whole set of rules of the ALTCS manual, and they regularly update it. In fact, they just updated it about a month and a half ago, and updated all of their requirements that they want to see in a properly drafted first party special needs trust. And that update, affects a lot of trusts. So there's a lot of trusts out there that have to be updated to coincide with the manual update. So basically the ALTCS manual is ALTCS ongoing rules that they tinker with from time to time, that we have to just remain aware of and make sure that anyone who's on benefits, meets their criteria. And so if that person has a special needs trust, from time to time, ALTCS might want updates to their special needs trust.
Mm-hmm. Thanks, Megan. Follow-up question, the acronym that's being pronounced ALTCS, that actually stands for ALTCS. It's just short for Arizona Long-Term Care System. We just had a quick question on that one. Megan, another question on the first party special needs trusts. You mentioned that in order to use one of those, the disabled individual who is the beneficiary has to be under the age of 65 in order to use that type of a trust. Is there any age limit for somebody to be the beneficiary of a third party special needs trust, meaning a trust created with the assets of a third party?
Absolutely not. It's a great question. I'm using the common example of parents providing for a child because that's often what we see. However, I have had many clients where it is the reverse, where it is adult child that is really taking care of parent who is disabled or in need of care or has long-term care costs arising from, say, dementia or Alzheimer's, something like that, where perhaps a special needs trust could be beneficial in that instance, right? So like, say, daughter wants to make sure if something happens to her that her mother is taken care of, because mom lives with daughter at home and daughter takes care of her. I mean, we see that all the time. So there's no age limit if you are a family member or a friend and you're trying to take care of somebody with your own money. Absolutely. Can always do that.
Okay. Another question. Who do you typically recommend serve as trustee over these types of trusts? A family member, or are there others if somebody doesn't have family?
So I would say, someone who's a good candidate to be a trustee, right? That's why, let's kind of flip to my basic list here of tasks that a trustee might have to do. They might have to gather assets of the deceased person. That means communicating with financial institutions, filling out paperwork, claiming accounts, keeping an accounting, meaning they have to keep track of everything that was spent, everything that is received. They have to be able to maybe coordinate and delegate to an investment advisor, or deal with a CPA, or seek advice from a lawyer. So you want somebody that has sufficient acumen or natural skills, I would say, to be able to do all of this. So sometimes I'll get questions like, you know, maybe there's a couple different adult children in the family, and, you know, sometimes people will feel obligated to pick one person, you know, maybe for certain reasons. Maybe they're the oldest, but parents might not think that they're the best suited for some of these tasks. I would always encourage clients to pick someone as trustee that would be able and willing, maybe have the time and the ability to be able to carry out these tasks, even if it's not, you know, who they feel like they should. You know, if in the case of a supplemental needs trust, the trust hopefully will be ongoing for quite a while. So it's a big endeavor to take on. So you definitely want someone that's willing and able to do it. If there's no obvious candidate, you know, we're always happy to introduce clients to the possibility of a licensed fiduciary or a bank and trust company. You know, there are professionals out there who do a great job at administering trusts. And so that's always a good option to explore. So, you know, I'm not against clients choosing someone they know personally, just so long as they really think that that person would be able and willing to do what is required.
Yeah. And with administering these types of trusts, I imagine it would also be important for whoever the trustee is, particularly a layperson, not a professional, to understand the ins and outs of all of the eligibility requirements of the public benefits that their beneficiary receives, and how not to make distributions from a trust like this that would disrupt those benefits.
Absolutely. I mean, we get questions all the time, and I think, you know, a trustee that's really doing their due diligence would probably, at the time they're trying to figure out what the rules are, they would seek advice from an elder law attorney so that they could understand, you know, how to make wise distributions that are helpful to the beneficiary and not interfering with their public benefits.
Right. So another question, Megan, has come in, you know, what happens if the trustee is not doing their job? Is there you know, who does the oversight, and what happens if it's discovered a trustee is not performing their duties appropriately?
So the oversight that there is, it really depends on what the trust says. So I'm gonna just flip back to like our 5 options for different types of trusts here. So all of these, the third-party trusts, right? Like whether it's from parents' revocable trust or last will and testament, or it's just a standalone document. There is a document that is drafted at some point setting forth the rules for the trust administration. And one of the rules is going to be, how often is an accounting due to the beneficiary or their legal representative? And is it also due to a court? Oftentimes it's not. And like a estate planning attorney or elder law attorney would not often draft accountings need to go to a court, but it's certainly possible. But I think, you know, most often the terms would be an annual accounting due to the beneficiary or their legal representative. So the trustee should be doing that. If let's say they're not doing an accounting at all, that's concerning. And I think, you know, the beneficiary or their legal representative could institute, maybe a soft first step would be, you know, hey, where's our accounting? And then they go aggressively increasing from there, potentially even removing the trustee by petition to the probate court. First party special needs trusts are, it depends. So I think they're more often subject to accountings to the court. I see that more often on those. And that could just be like dependent on how they were set up. So if they were set up as part of a court process through a guardianship conservatorship proceeding, you know, oftentimes there'll be annual accountings to the court. So certainly when the court receives an accounting, there's a little more oversight than when there's no accounting being received, but you know, sometimes when things are going wrong, it can be caught by all sorts of different people. It could be caught by, you know, someone who's close with the beneficiary or the beneficiary themselves saying like, hey, I'm just not getting information that I need to get, or I haven't seen any distributions, or this looks funny. Sometimes it could be the bank flagging things. Sometimes there might be an accounting sent out, but it looks alarming, you know. I don't know. Does that answer the question?
I think so.
Okay.
Yeah. So, and maybe along this vein, you know, for somebody who has concern about administration of a trust and having another party besides the disabled individual or their legal representative reviewing the accountings, frequently we'll see situations where it's a third party special needs trust. So mom, dad are creating this, and they'll nominate a professional entity, whether that's a licensed fiduciary or a bank and trust company that agrees to serve as trustee over these types of trusts, but they still want family involved. So sometimes they'll draft into the trust, or they'll have us draft into the trust, a requirement that somebody they name shall also be provided with accountings. We may even draft that individual in a role in the trust, formalized role called a trust protector. So, you know, there are ways to require that the trustee provide information and be able to receive information from a responsible relative or dear family friend, particularly when you've got an institution or a professional entity serving as trustee. So I just thought I'd throw that in there because that may be the concern, you know. So
yeah, there are so many safeguards that can be drafted in there, but you know, as to what happens, it really depends on what is drafted in there, which I would say is only another reason to be careful about how it's drafted, you know, to make sure that advice is being sought from someone who kind of thinks about these things or has been around for some of the things that have gone wrong and
knows how to draft around it. Always good advice. So if anybody have a few minutes left here, Megan, I don't know if you have any parting thoughts or sage words of advice for people looking to use special needs trusts for their families or potentially for themselves. And if anybody's has any, you know, more questions, we can pop those into the Q&A really quick, and we'll get to those.
My final thought would just be, you know, oftentimes I'll try and delicately say this, but I think it's good maybe to plainly say it as well. This is a time or a situation where my advice to families would be just to seek competent advice. You want someone advising on a special needs trust or preparing it that has experience in this area. It's just not an area where you want like a document preparer or something like that to be preparing, just because there are so many layers of regulations that apply to this. It's such a niche area, and it's so important. The stakes are so high. You know, the value of a beneficiary's lifetime Medicaid benefits or lifetime Social Security benefits. I mean, it's quantifiable because I see Medicaid's claims at the end of life, and these are huge numbers. Like when you see on paper the value of what someone's received from Medicaid, I mean, it's so valuable, it's so worth protecting, and it would be such a shame to jeopardize it. And then if it's drafted wrong or done wrong, I mean, sure, we always have the first party special needs trust as a fix, but really not always, right? Because it has to be funded before age 65, and you're subjecting the assets to a Medicaid payback. And I'm really happy that Medicaid exists, but I think people are frequently disappointed when that Medicaid payback comes into fruition. So,
Yeah, most parents would choose to leave money to a charity
yeah.
or another loved one before they would pick the state agency.
Totally.
I have yet to have a parent say my number one choice is the state agency.
Yeah.
So, all right. Well, this was great, Megan. Thank you so much for all of this valuable information. A recording of this will be put onto the firm's YouTube channel. As Megan mentioned, we did a webinar yesterday on wills versus trusts and how to determine which is right for your estate plan. That will also be up on YouTube, and we have another webinar coming tomorrow on how to avoid probate. So all of these webinars that we're doing are being recorded, and I anticipate they'll be up on our YouTube channel probably starting sometime next week. So, you know, I know there's jam-packed information. It's kind of hard to take it all in at one time. So feel free to go back, listen to the recordings. Also, the best advice is going to be specific advice to your family. So
Yeah.
we're always here to help. If you're in Arizona and any of this is resonating with you, you just think you need a review or you have specific questions, contact our office. You can call us or email us, and we can get you a consultation with one of us or one of our other fine attorneys and make sure we dive in and give you the best advice for you and your family. So, Megan, thank you so much. And thank you everybody for attending today. We hope you found this helpful, and stay tuned. We have more webinars coming. We're going to be doing a series every month on a variety of different topics. So we're here to provide the information to the community because we know good information is hard to come by. So thank you, everyone.